Welcome to the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. We go through domain name legal news, and we also review a few UDRP cases. Excuse me today, I got a bit of a cold, but I think we're going to make it through, try to get through this day fairly quickly. We got some pretty cool topics, got four actually, good cases to review. I'd like to start by saying hi to my co-hosts, Jeff Neuman and David Michaels. Hi, Jeff, how are you today?
Whoa, I'm doing well. Sorry to hear that you're a little under the weather, but yeah, we got some good cases. On the personal note, I just announced that I'm co-producing a concert just after NamesCom, but it's in London. Um, it's a concert with the original cast of a show that I uh, was producing in London in just before the.
You cut off there a little at the
Is
end.
it just me or Jeff breaking up?
Yeah, no, you broke up there at
Oh,
the end. There you go.
sorry.
You're better now. So it was a musical, and now they're going to do a concert of the songs.
Yeah, yeah. So not the full musical, but a concert with many of the original cast that was in the show. So kind of fun.
Yeah, very cool. All right, I look forward to hearing more about that too from you. But all right, hey David, how's everything going in your area, in your neck of the woods?
It's all right. It's warm, overcast, expecting a lot more storms. We've had more rain this week and more thunderstorms this week than all summer.
Yep, I was hearing that too. My family, mom and dad, are back in the Midwest, back in Indiana, and they said, yeah, last couple of days pretty crazy, but um, it's nice. Usually in the center of the country and up in the United States, you miss a lot of the hurricanes because, of course, by the time it gets that far inland, it's usually just if it is tropical storms, usually not even that, just thunderstorms. But as soon as I say that, they do get a lot of rain, so some flash flooding sometimes. But yeah, I hear from Toronto down to, I mean, through Tennessee, loaded up with rainy weather. Um, if anybody wants to follow along, you can always follow along. We have a website, dnlshow.com. And for you domain investors, remember we used to be on dnltv.com for the first few years, and then I sold that name right out from underneath us. Some company in Europe wanted it because they did manufacture some kind of television. I don't know. But they reached out and I said, yeah, well, I'm going to need, I think I sold it for, 10 grand, 11 grand. Was it 13 their money and 10 mine? I can't remember. I think I got like 11 out of it. But yeah, I will sell the shirt off my back. I mean, everything's for sale. And I also knew, so we'll just get dnlshow.com. Didn't miss a beat. Okay, so that's our website, dnlshow.com. You can see a link that says outline right there. And you can also just go to dnlshow.com/outline, and you can see what we're going to be covering today. On that outline, by the way, every week, I always put the show link. So if for some reason I don't know, you can't find it on X, which it's always under my profile, you can go right to the outline, dnlshow.com/outline, and you'll see the show link. I'll tell you, I'm pretty happy. Today's show 237. We're getting close to 5 years, but it is nice, doing it with Jeff and David. We do this, make it real simple. Like I said, you heard us. We come in, say hi to each other, and get rolling on the news. Whatever. There's so much domain news. We try to stick to the legal areas of it, or domain disputes and so on. But we'll have other, topics sometimes that aren't necessarily legal related. And then every once in a while, we have some guests. And yeah, I'm one of those, I keep a lot of text messages, and I was going through them the other day, and I saw a message, one from Howard New, and I'll tell you, it's like a friend that's no longer with us, but he was a guest on this show. But it's weird. I know a lot of people do that with family and friends. You haven't deleted stuff, and it's like, geez, time goes by fast, though. Just a couple of years ago when Howard was on the show, February 28th, 2023, and I have a link to that replay at our website, dnlshow.com/outline. At the bottom, you can see past special guests. I got most of them there. But so we do have guests every once in a while. Today, we're going to, this first story I sort of wanted to back off of. Now, we'll talk about it, but it was really the legal topic. The LA Rams filed a UDRP against, for the domain Rams, RAMS.com. And the reason I wanted to back off of it a little was a friend of mine, you guys know the guy, but I won't say his name just yet, is representing the domain owner. And we don't want to really taint the panel pool. I think it was a WIPO case, so I don't think Jeff would be part of it unless it's a 3-member panel, which it likely will be. So it's I didn't want to talk much about the case because Jeffrey's a panelist, and he may end up being a panelist on this case. They filed the case that Los Angeles Rams did. It hasn't been assigned to a panelist yet. Anyway, interesting case, but some things we can say about it. Well, David, you can make some comments on it, and then I'll make some general comments, and Jeff and I will make some general comments. But what do you think? You heard about the LA Rams case. Do you think it's unusual that they go after such a generic name, or do you think they have maybe rights and a right to do it in this case?
I think that since there are thousands of companies with the name Rams in it, literally at least 2,000 active businesses that start with the word Rams around the world, including the United States, I don't think that there is anybody who can claim exclusive rights to the word Rams. Yeah. It doesn't matter that they have a trademark or not. There's a sports team called the LA Rams. That's their brand. They're not the Rams. They're the LA Rams.
Well, let me set up no, I agree with you. Let me set up this, Jeff, a set of facts, and you're the panelist, and it'd be something like this. So I just acquired the name purple.ai. Okay, let's say I did, and I spent $100,000 on it, and I get it, and not only the same day I contact Purple Mattress, and I say, listen, I know you're coming out with some AI features to your mattress, some bullshit, I don't know. But as soon as I bought this, because I had you in mind, I want to sell it to you for $6 million, or make that $16 million. Anyway, it's $16 million. And I know this is the right fit for you. So what if when someone, it's a generic name, purple.com is generic, no doubt about it, but I specifically bought it and I targeted this one company. Am I in jeopardy of losing the name through a UDRP?
Yeah, I mean, that's the classic definition of cyber squatting, right? I mean, if you buy a name with the sole intent to sell it to a trademark owner, in exchange for compensation that exceeds the cost of registration, that is the classic definition. No matter whether no matter whether it's generic or descriptive, you cannot, at least according to the ACPA in the United States. So no, you can't do that even if the mark is generic.
Okay, so there's a lot of different facts in the Rams case that we don't know of, but we just wanted to make a point to domain investors. If you buy a name and you're aware that it has somebody's mark in it, it's okay to even be aware that there's a trademark that maybe is exactly the domain that you have, or your domain includes it. But when you're reaching out to companies, you certainly want to reach out to numerous companies and say, you're one of many who I think could benefit from this domain name. You don't want to target one company. Sometimes we've seen cases where they consider it targeting where you have reached out to more than one. But you just want to do some things to help protect yourself in case down the road you do have to defend yourself. You don't want to. So Jeff made a good point. You acquire a very generic name, you still cannot target a specific company and then ask for a lot more than your out-of-pocket costs, or that's exactly what the UDRP was really set up for. I think people just immediately think when they get a generic name, they're safe and they can do what they want. So you really can't. All right, this next piece of news I wanted to talk about, we'll spend some time on. Excuse me. Jeff, go on mute when you're not talking, please.
Apologies. Yep.
This next, very interesting, Trademarkia, the company that's basically, it's like legal. Let me see what the name of their company is. It's like legal something. I'll look it up. But anyway, they filed this case I thought interesting against Squad Help LLC. So basically, Trademarkia is going after Squad Help because Squad Help launched their trademark service under trademark.io. Trademarkia felt like Trademarkia is real similar to Trademarkio, and that's why they filed the case. But they're really sort of, I say, stretching it because they mention in the lawsuit that Squad Help did also purchase trademark.ai. So basically this lawsuit that we'll get into a little bit is Trademarkia as the plaintiff, Squad Help, that's still their company name, Squad Help LLC, also known as Adam now, is the defendant. And Trademarkia says you're starting a company with a confusingly similar name, same exact set of services that you're offering, and really that is basically it. Well, I guess David, jump to you first. There's a lot to this case. I went through, and I guess there was an amendment yesterday. I haven't seen the amendment to this complaint, but you have to take a look at that maybe for next week. But what do you see in this case? Trademarkia.com, and is Adam really at risk of losing the rights to use the domain trademark.io and have some penalties levied against them?
I don't think so. And first of all, as a matter of jurisdiction, there's no personal jurisdiction over Squad Help in the Northern District of California. Squad Help does not have any offices there. It does not have any employees there. It doesn't do business there specifically. It has a website accessible nationwide, but that does not confer jurisdiction to Northern District of California. There's a big case that got decided called Ford Motor versus Montana Superior Court in 2021 by the U.S. Supreme Court. And there's been a few other cases affirming that decision and following it in different ways. And there's just no jurisdiction to sue Squad Help in the Northern District of California. But let's go to the real reason why this case was filed. Trademarkia.ai is also another website run by Legal Force, and they're automating trademark searches there. You can try Trademarkia AI at trademarkiaai.ai. That's a real mouthful. They'd really love to own trademark.ai. That's what they want. The problem is Squad Help does not own it. Dharmesh Shah owns it. It's parked on his agent.ai platform where you can do trademark searches. It's not very robust, but it's a skeleton of a website that works. So if they want to go after, if Legal Force wants to sue Dharmesh, well, Dharmesh has all the money in the world to fight back against Legal Force, all the money he would ever need. So I'm not saying that Squad Help is poor, but hey, he's not a billionaire. But anyway, that's the motivation behind the lawsuit. And there is no trademark in the word trademark for trademark services. It's a generic term. Everybody can use it. One of the first names I registered was trademarks.ca. I registered on behalf of the law firm where I was working at. Stupid me, I should just registered my own name and just kept quiet about it. But oh yeah, here's my name. Do you want it? So anyway, I should have kept it. Yeah, that's the motivation behind this lawsuit. It's a bogus lawsuit. The biggest problem I see with it are the allegations about John Berryhill's comments on on X. And those comments are taken out of context and they are stretching what John's actually saying. They're misinterpreting that. And where they made for an improper purpose, like, for example, to conflict John out of representing Squad Help, in the Northern District of California because they have local rules in California, rules of professional conduct that would potentially prevent him from testifying or actually representing Squad Help because he'd have to be testifying as to what he meant behind his posts. So it's not just that he made these posts and what they say, but the interpretation of those posts is what's at issue. So I think that was a strategic move by Raj, the owner of Legal Force. He's a known vexatious litigant. He's notorious. That's all I want to say about him.
Jeff,
What do you think, Jeff?
yeah, Jeff, if they didn't have, if it wasn't the domains trademark.io and trademark.ai, if it was trademark.ventures, trademark.solutions, do you think Trademarkia would have filed this?
No, I mean, I can't say that they definitely wouldn't have filed it. But I think because it's the, um, the AI is involved there, or IO is viewed by them to be, I guess, close, and certainly IO, you have CCTLDs, which normally I don't think they would go after, except this one is these two, actually, IO or AI, are generally seen as more generic, at least under the law, than country codes. Um, but look, John's now going to be an unwilling witness in this case, which is unfortunate. I don't know if they would have selected John, and John knows that if he's going to make a comment on a case, regardless of the comment, that he's not intending to represent one of the parties. Um, I think that John knows that. He's very careful about making any kind of comments on any. He's careful about coming on this show, right? Because he doesn't want to result in a conflict. I mean, you know, he said that on a bunch of. He won't even join some other calls, even of professionals talking about cases, because he doesn't want that to be seen as giving legal advice or others. So if John comments on something, it means he knows he's not going to um, be representing one or the other party, or even probably, well, he could be an expert. Um, so, look, I think it was filed for a number of reasons, and I think um, they sort of got Adam to back down. So now they're not marketing it as trademark.io anymore. I think they're just marking it as trademark by Squad Help, or trademark by Adam. Sorry. So, one could argue that the lawsuit sort of had its intended impact, um, in that they're not, even though they're at trademark.io, they're now marketing their service as trademark by Adam. So
So those changes happened before the lawsuit was filed, and they're mentioned in the complaint.
yeah, no, I saw that, but I think it kind of sends a message that, if you're going to continue to brand yourself as IO, we're coming after you. It's kind of one of those things put in there as sort of a um, settlement. It's always good to put in lawsuits if you think there's going to be a way out. And Trademarkia might be happy if Adam changes solely to trademark by Adam. Of course, it would be happier if it didn't use the site trademark.io, but if it's not marketing itself as trademark.io, it's got a lot harder case anyway. It'll be interesting to follow this. I agree with David in the sense that, you can't stop someone from using the term trademark, and whether it's trademark.io, trademark.us, or trademark.com, net, org, or any of the others, that's a risk Trademarkia took on when it went for the mark. It knew when it applied for Trademarkia that it could not stop someone from using the term trademark in their trademark.
Yeah, and
So,
the other
yeah.
problem is the mark Trademarkia might be actually invalid because it claims the word itself is generic to the genus. So there is academia as a term for academics, and the AI is like a Latin version of that, and that's like a genus of the topic. So that might have, flew over the examiner's head initially, but that makes the trademark itself vulnerable.
Yeah, but how old is the trademark? I haven't taken a
Doesn't
look.
matter.
What's that?
It doesn't matter how old it is.
No,
It
it
could be.
does, because if it's over 5 years, it's incontestable. Then you have to argue that it's become generic, and others would have to argue that that term in and of itself is generic. So it's a
There are
lot hard.
several.
It's a lot harder to go after a incontestable mark than that.
So incontestable has a limited meaning. It doesn't mean what you think it means. They limit the number of grounds for cancellation. Genericness is one of them, but there are many others, at least 5 others. I'll send you a list.
Yeah, no, I'm familiar with that. It's just that they'd have to, again, it's much more difficult to invalidate an initial um, uh, trademark examiner's um, assertion or evaluation than it would seem. And it's a lot, I think Trademarkia is fine for a trademark. Um, it's a lot different than academia because, but you're right. I mean, it's kind of taking a slight risk with filing this lawsuit.
Trademarkia is a fair mark. It is different than academia. Trademarkia was registered 2011. They bring it up in their case that yeah, it was uncontested then, and we have rights to Trademarkia. They are simply saying trademark.io, Trademarkio, and Trademark AI, too similar. Like basically, we saw in a case Duncan.coffee, I believe it was, when the right of the dot is part of the trademark, and the panelist rules that the the only person really, I guess not the only person that would have rights to it would be the trademark owner. In that case, it was Duncan who won the case. I've always said, of course, you have some free speech rights and some non-commercial rights to really any name, but the point is they're starting to use to the right of the dot the extension. So if it's a company, Jeff, you got at least a common law mark for JJN Solutions. If somebody started doing business as JJ,
How dare you? I have a trademark
okay,
for
so you
that.
have a
How
trademark.
dare you?
So if somebody had JJN Solutions, and maybe they do, well, you certainly would have. I mean, certainly have a standing, but certainly have a good chance of getting that, depending on their actions, of course, unless they did, like we said, something they were trying to do some free speech site. But the point is, to the right of the dot, people are saying yes, it does. It's not generic like in the past where .com you just you just discard it. .org, .net. So in this case, Trademarkia is saying it's just too confusing with that .io and the .ai. And they said, for those of you who wonder what we're, want to be brought up to speed, Trademarkia filed a lawsuit against Adam for that service, trademark.io. Subsequently, Adam, really right before the lawsuit was filed, they changed their this trademark product to Trademark by Adam. In this complaint that's been amended, and we haven't looked at the amendment, it just was amended yesterday, and I had a chance to look at it. But in this complaint, Trademarkia says, hey, there's a Dr. John Berryhill who's well known in the domain space, who was commenting on X that, oh, look, Adam must be ready to fight Trademarkia in that realm of, offering trademark services, which, like David said, that's really what he said. They tried to take it out of context and said, hey, they better get ready for an infringement fight or something. John didn't say that. John just said, hey, it looks like they're going to be offering that same service. Well, like you said, a lot of people can offer trademark services. It's stupid. Okay, so a lot of companies do offer it. A lot of IP attorneys offer it. They just, some of them offer it just through their law firm. They don't necessarily brand, this extra trademark service. Okay, it's like LegalZoom, or there was some other ones I was thinking, when they offer you some legal services. Trademarkia just offers you help with, filing for a trademark, protecting your mark, just consulting about a trademark for your business. So Adam, of course, wanted to do it. Trademarkia brings up in their complaint, and we thought it was interesting. They bring up John's post on X, and they take him out of context. They bring up Domain Gang filing an article about some things that, long story short, is on the Adam website, the Trademark by Adam website. There were a few lawyers there, 3 lawyers, pictures. 2 of them, I guess, contacted Adam and said, take the pictures down because we're not, we don't want them there, and we're not part of that team that you're saying is whatever. Basically say we're not working with you in that capacity where you can say we're partners and use our pictures. Adam took it down. In the complaint, Trademarkia acts like they're guilty of stuff. They're just like pointing out things. But it was interesting that they brought up recent articles and recent posts that were made in the domain space, on Domain Gang and on X, in the last 2 weeks. And then they bring up, and furthermore, Adam bought trademark.ai for $39,000, which shows they're, not letting off the gas. They're trying to disrupt our business. And that basically what, all of you guys have learned so much, I would say maybe not just from this room, but when I was on a call, I forget what the call the other day, but I mean, maybe it was one of these spaces, but so many domain investors know about trademarks, that in the U.S. they must be used. You can't just file if you're intending to use. You can file, but you're not going to get a registered mark until it's actually in use. But just domain investors are getting so well versed on trademark law and basically UDRPs that it's important to it was important to bring up that just because Adam spends $39,000 on trademark.ai, it doesn't mean that they're guilty and they're anyway trying to infringe. I guess I know my point was Trademarkia was saying that they are trying, when someone has a trademark and somebody else is using a similar name, sometimes, and it's okay to have a user go to a website, and initially there's sometimes a little bit of confusion, but once they get to that website, if that confusion is cleared up fast by a disclaimer that says we're not related to ABC Network and we're a separate company and we do this other business and we're not who you thought, that usually suffices and is okay. But in this case, Trademarkia said, well, when people go there, they might be confused at the start, and then before they get unconfused, we lose the lead and don't have a chance to close them on our paid services. So we don't like the idea that somebody looking for trademark services could possibly land there instead of us, and then we lose the business. So they were just basically bringing up that obviously they think they have a right to it. And finally, I'll say, mentioned in the article, talked about DARPA speaking at NamesCon and how John speaking at NamesCon, and these are thought leaders in the space. And anyway, it was really trying to make it looked to me like trying to make a meal out of just spices. There's nothing there. There's no real food. They're just coming up with all sorts of small things. And I'm looking forward to see who represents Adam and their response, and we'll stay on top of this. Samit had raised his hand. He brought him up here, and then he went back down. So Samit, if you had something you wanted to share on this topic, raise your hand, and we'll bring you back up. But as we move on.
So I've not been on, this is Jeff, I've not been on Twitter or social media. I've been busy, but has John commented further on this?
I don't believe so. I'm going to have to take a look, but I haven't, when I say I don't believe so, I can't imagine if it strikes him, he certainly will. So maybe he's laid off because he may assist or consult with the people that are representing Adam. Who knows? It's a small world in the domain space. We know that. And the reason why I said earlier didn't want to really talk about the rams.com UDRP yet is because it was just filed, and there's a lot of, we don't know who the panelist is going to be, and don't want to not influence but tamper with, we don't know all the facts in the case. But it's interesting that a big organization like the NFL, Los Angeles Rams, would go after such a generic name, Rams.com. Why they feel they have a case? Well, I guess they'll set it in their complaint, their UDRP complaint. But there's a lot of panelists that we know and a lot of domain lawyers that we know. So I suspect, matter of fact, I know we're going to see, well-known representation for the domain owner, and we wish them luck. All right. Our cases today, I'm gonna get to them in just a second. But Jeff, so Laude, that's the company you worked for. They're based out of London, but they're a worldwide organization, right? I mean, they have offices here in the U.S. Is that correct?
Yep, I started their U.S. based office, so yep, they do, and this you know this is, I think, a good thing for them, obviously, and I also think it's good for FairWinds, who hasn't been seen too much or heard from much in the past few years, but they do have a strong base of clients. So yeah, I think it's look, I don't know what Laude paid for it. I don't know how much it's worth, but certainly it gives them much more access to U.S. based companies. So we'll see.
Yep. Tradewinds is out of DC. That's who Jeff's talking about. So Laude bought Tradewinds. They're both
FairWinds. It's called FairWinds.
Fairwinds, right?
Yeah.
Fairwinds sounds like a hotel. But so both of them are big, sort of big, I say, commercial managers for domain managers for companies. In my opinion, they offer a lot of other services. In this case, we're talking about the new GTLDs. The next round, Tradewinds helped companies apply for, a lot of brands apply in the last round. So did Laude. So together, that's why they said in the articles, you can look, I believe it was Domain Name Wire or Domain Gang. I put on our outline that talks about it. If you're interested, go ahead and click that link. Hey, Bradley, nice to have you. What's on your mind?
Hi, thank you, Todd. I was regarding the Trademarkia. I had just a couple questions. Suppose the right of the dot was IA instead of IO or OI. You know what I mean? So that it was the suffix of trademark that Trademarkia uses matched the right of the dot. Would that matter? And then another question was, suppose, like, for example, I looked up trademarkcom.com. You know what I mean? Just to try to kind of, juggle what the issues are in this case if it was different.
Yeah. So sometimes the right of the dot can actually make a big difference. Like there was a case where someone had Toys R US, right? It was the US country code, but you look at it together, it's Toys R Us, and so that would be infringing. So yes, that right of the dot can absolutely matter. Plus, if it's in, if the right of the dot is in a specific kind of goods or service. So let's say you own the term, or you have your Apple, right? You're the company Apple. Can you go after someone who's got Apple.us? Maybe not. But can you go after someone that's got Apple.computer? Absolutely, right? Because so that certainly could be. But this case is a little bit interesting because it's like the mark. So there was a hairspray, right, called Aquanet. And the question is, like before the net, so someone at aqua, like the color, .net, would that be something that Aquanet, the hairspray, could automatically allege would be infringing? Now, perhaps if the site were being used for Hairspray, yeah, I could see that. But if it's used for anything else, like to describe the color blue, probably not. Or to describe it as not the color blue, but the color aqua in its generic sense, then no. In this case, I kind of think it's very similar, or it would be the reverse, where you'd have trademark.io, but the term trademark in and of itself is not trademarkable. It's descriptive. And, it only becomes the trademarkia, if there was a .ia. Uh, it's not something I think that has a definitive answer, that you can't say automatically yes or automatically no. You have to look at it as a whole.
I see. Yeah, those are good examples where you brought up the Aquanet and the Toys R Us. So I just looked up trademark.com, and that goes to Clarivate, which is intellectual property, but science and health and academia. So, I mean, even trademark.com isn't used specifically for trademarks. And trademarkcom.com is the name find name. That's on a lander. So I just thank you for clarifying that. So in essence, maybe trademark.ia would be a stronger case for Trademarkia than the IO.
Yeah, I think that's right, because I think at that point they would be arguing that it's the exact mark that's being registered. I'm not saying it would succeed. It would depend on .ia and whether it's. I mean, yeah, it would depend on a bunch of different things. But yes, it would be a stronger case if it was .ia.
Yeah.
Thank you, Jeff.
And say
Thank you,
say
Todd.
no problem. Say if it was Trademarkio was the trademark that they had for years, and we're seeing these hacks. Domain hack is really landing on someone else's mark. I mean, is Jeff mentioned it. Toysr.us, aqua.net. So by using the extension, that's really completing someone's trademark. So if this was Trademarkio and then Adam did that, Adam is still going to defend itself, I'm sure, by saying to the right of the dot is generic. So that's how we look at it. It's always been, there's several court cases that say to the right of the dot is generic,
Yeah,
but like,
and they'll also argue that from a sound or oral perspective, it's trademark.io, not trademarkio. No one's going to pronounce it trademarkio, right? That's very different than the Toys R Us, right? Because people, when they look at it, are not going to go, when they see Toys R Us, they're just going to think it's a period in the wrong place, and so they would think from a sound perspective, you pronounce the dot, or you wouldn't pronounce the dot for the Toys R Us. But for this, everyone knows that it's trademark.io, and that's how they would market it, not trademarkio.
Right. That's a very good point too, because homonyms are kind of possibly being infringed. I'm actually, Todd, when you mentioned Howard New, what a special man that he was, and I knew him personally, and we actually had a discussion once about cyber and cyber, and I was spelling it differently, and he said, you can get in trouble if it sounds the same, you know. So when you're explaining, when you use the word phonetically and you interject, it's a .io, it changes it completely, because you don't read it and say it as if there's no dot there, and that's a big difference.
yeah, there's a lot we're gonna follow this case, and next week we'll talk about it because there's an amendment coming up to it. But Anthony, thanks for joining us. Did you have a comment or question about this case or anything else? Come in, Anthony. Come in. It's always a picture of him walking through New York, waving to people, pointing to people. He's walking down like Fifth Avenue. Hey, Anthony, well, when you get back where you can speak, just come off mute and I'll yell at you for interrupting. But yeah, thanks for joining us too, Anthony. You're on stage just in case you're listening. Okay, we're going to get to our cases. Before we do that, if you're looking at the outline, up until they tell me that we can't nominate anymore, I'm going to tell you the ICA has nominations open for the Lonnie Borck Memorial Award. I'm recommending that we all nominate Jeffrey Neuman. I know Jeff's not saying anything about it, but that's who I nominated. I appreciate some others that are helping me out by nominating. He's like, it's like American Idol. Let's call in. But I put the link there because if you nominate someone for the Lonnie Borck Award, you need to have their email address, and you can see I've posted that on there. Also, there's 2 awards now they give out each year. The Lonnie Borck Memorial Award, which is on like its 7th or 8th time. And then it's the second time now for this Trailblazer Award. The first one was won by Darpin, which, congratulations. But I feel like that's like somebody new to the party. He's busting his ass, no doubt. And all the work they've done at Adam is pretty outstanding. But I'm recommending that Chad Folkening be nominated for the Trailblazer Award because somebody that's been in the domain space for 30 years, constantly breaking new ground, pioneering new technologies. And anyway, so if you can go to our outline, you'll see where you can click and nominate for the Lonnie Borck Award and for the Trailblazer Award. Appreciate if you help me out there. The first case that we're going to go through today, this one is a friend of mine who is the domain owner, swisslife.org, and he answered the case himself, and I'm going to go ahead and ruin it for you. He was unsuccessful when I think he did, well, he wanted to do it himself, and he already had the answer before we could really give any more specifics. I mean, I say we, because I was telling him, hey, you might want to include this, you might not want to do this, and so on. But anyway, Swiss Life, the big insurance company out of Switzerland, was the complainant in this case. Swisslife.org is the domain name. Okay, this gentleman is a U.S. domain investor, businessman, but complainant. Give you a little background. Okay, so they were founded in 1857, but they didn't really start using the name Swiss Life until 2002. Okay, they have many European trademarks since 1994. They got their U.S. trademark in 2006. I'd guess half the people in here, well, in the United States, the ones that are in the U.S., more than half probably heard of Swiss Life, but maybe not. They might have thought of, Swiss Miss. They may think it's a cookie. Who knows? But the point is, so I've heard of them, but I'm in the finance business, so I had heard of Swiss Life, of course. But I think there's some people that wouldn't know Swiss Life. This respondent, the domain owner, acquired the domain, and he mentioned this in his response because the complainant said, we see the domain was registered in May of 1998. The respondent said, I bought the name at GoDaddy expired auctions, but I didn't even, I bought it because I checked out names like uklife.org and aussielife.org and even texaslife.org, and I thought it's a great geo name plus life. And I was thinking to myself, I own sincitylife.com. But so the respondent bought the name because he liked, like Swiss Life, be like you, like I said, like UK Life. The panelist didn't like that so much because the panelist felt like he would at least looked at the .com, which the complainant is on. So thinking if you're buying a .org, you probably would have seen the SwissLife.com. So you saying that you weren't familiar with this company until you received this UDRP is really what I think leaned the panel towards the complainant. Just felt like, no, I don't believe this domain owner didn't know of SwissLife.com. There's a lot of other little facts in this case that I think are interesting. David, go to you first. SwissLife.org is the domain name. the big company comes after the individual business person, domain investor in the U.S. And seems like, in my opinion, this panelist already had their sort of finger on the scale of the brand of the complainant. What did you see when you looked at this?
I was surprised. I was wondering, what is Swiss Life? I've never heard of them before. So I checked them on Google Trends. Less than 1% of their global traffic comes from, or search for the term Swiss Life comes from the United States or North America. Most of it is around France, Switzerland, um, Luxembourg, and Germany. So they also have a U.S. trademark. They got it in 2004. The registration date of this name is 1998. And so I was wondering, when did your friend receive or obtain this name from the GoDaddy auctions? But then I saw that the U.S. trademark actually has a disclaimer for the words Swiss Life, because the examiner says specifically that the term Swiss Life is generic. And or generic or descriptive. Let me check that again. Hold on. It's put it in the post here. Both descriptive when they do not use a non-descriptive word. It's descriptive of life insurance in Switzerland. So they disclaimed it, expressly disclaimed it. So that's it shows up in the registration. And the panelist is Luca Barbero, and he didn't take that into account. Now, the registrant is based in the US. So why doesn't the genericness finding by the USPTO and their express disclaimer say, like, come up in the discussion of the opinion? But no, it doesn't. He just talks about international registrations and how there's a European registration. And this USPTO trademark is just mentioned once as a figurative mark. Well, it's because it's a design element. That's the only way it got registered. But then a few years later, when they came up for renewal, they submitted a Section 71 request, which means, oh, we're not using it. We have excusable non-use. So here's our excuse. And they kept their registration. So they don't market it in the United States. They have no common law rights in the United States. I find it a problem where you can take a generic term or merely descriptive term, register it in a foreign country that has lower examination standards, and then go after those names in the United States. I find that obscene. I find that this whole decision lacks credibility, and it really is a bad stain on the UDRP process. I'm writing an article about this case. Luca is definitely biased, and yeah, he should not be a panelist. That's all I want to say for right now.
I didn't like this decision. It was a transfer, Jeff. So the person transferred SwissLife.org away from the domain owner for, well, Jeff, explain why the reason Luca Barbero transferred this away.
He's European. And I think in Europe, they certainly have a lot more respect, not respect, but they certainly have a lot more emphasis on protecting geographic marks than we do here in the US. So if something's protected, um, usually Swiss, I think, is protected by law, which makes it subject to the Paris Convention. But still, the U.S. does not. The U.S. is much more lenient on geographic designations than would be Europe. So, a couple things, right? So Swiss Life is much more common or is much more well known in Switzerland. And I think Luca probably just said, well, because it's well known, in Europe, under the Paris Convention, it should be treated as well known in the US, and therefore should somehow be attributed to um, the 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 registrant at this point should have knowledge. this whole should have had knowledge of, it's hard to kind of grasp that in this decision, because Swiss Life is not well known here, or they certainly didn't show that it was well known here, and showing that it's well known in Europe, and therefore it should be protected under the Paris Convention Treaty, that's an argument you make in court for infringement. That's not a great argument for a domain name. And so, I have an issue with it. I think they would have chosen a US based panelist. I'm not sure they would have gotten the same decision.
I don't know the price that he paid for this, but he certainly shouldn't have lost this name. The panelist said, well, first, the respondent said, I acquired the disputed domain purely for the geodescriptiveness of it. Swiss Life, thought it was cool, saw that there was other countries, like I said, UK Life, Aussie Life. So Aussie Life is a great similar example to show. And then the panel comes in and says, I find it unlikely that the respondent was unaware of the complainant. So maybe the respondent, well, if he wasn't aware, David said he wasn't aware. A lot of people aren't aware of Swiss Life. You can't, if you're not aware, you tell the truth. I didn't know of the company. And then even if he did check the .com, and of course he saw the .com's taken, all right, it's taken by some company. So is a lot of the other. Doesn't mean I'm aware of the company. You're right, Jeff. The panelist said that the domain owner had a duty to sort of, before he bought this name, check some things out. Basically, he was saying there's willful blindness if he bought this name without checking to see if they're trademarks. So that's already, bull. We know you don't have a duty to go through and check trademarks. If you've never heard of it, you don't know of it, you don't know of it. And there's, I think one thing that the respondent had done wrong here that could have helped him is this domain was registered in 1998. The complainant didn't mention anything about the respondent acquiring the name recently. So the panelist might not have ever known. I think what the respondent could have done here is not talked about when they acquired it. They could have just said, I was never aware, I was never aware of this mark, and I mean of them, and I've owned this name. Doesn't want to lie and say he's owned it since '98.
All right, let me try to be devil's advocate on this one.
Okay.
So, if you're buying a name, let's say it's not a .com name, as someone that sells domain names, aren't you going to check the .com? I mean, really.
That's what I was going to bring up. That is the most. I think this was more about the panelists perceiving that it was disingenuous for him to use that excuse. Todd, you're right. If he would have said, I saw that it was an insurance company or something, then then I had no problem getting it because I'm not going to be using it for that purpose or something like that. But he probably said this guy had to look. Any domainer who's buying a domain name under a .org is going to want it as a .com first. So they should be looking at that.
Well, a domainer could have, Jeff, and I'll answer. I'm a domainer, so I did. I checked instant domain search under extensions, and I saw, the .com was registered, the .net was registered, the .app, all those were registered. So what? I got the .org, but I did see all those other ones were registered. Did I go to every site to see who's on the .com, who's on the .net? I didn't care. I knew I couldn't get them, but I figured they probably had them because just like I like Swiss Life, I figured they would like it, Swiss Life. But and even if the person went there and saw, geez, now you see a big beautiful site, it still could be one person. You don't, you go to the site, you're like, you know what? I'm going to go and research the history, their board, how long they've been around, if it's a real company, what are their revenue? So many times the person might have said, yeah, I did see that the .com was registered. Basically.
Right, but he didn't say that. In this case, he said, I didn't know them. I don't know anything about them.
Well, he said I didn't know that. But that he didn't say that he didn't know that the .com was registered. He knew the .com was registered, by somebody who also liked it. But that doesn't mean he knows the
Right, but there's a much better way to argue it. Of course, we didn't see the actual response, but I mean that's the thing. If you're going to get a different extension, or you know that there's another company out there, you shouldn't say that you never heard of them, um, or never saw them. You should just say, yeah, I saw they had the .com, but this is generic terms, and I don't know anything about this Swiss Life group or what they do. They're not here in the U.S. They're not, or they're not in my local area, and I'm going to use it for whatever you're going to use it for. It's it's sometimes tougher to make the argument that I've not heard of them, and the first thing you see as soon as you get it is it's for sale.
So Jeff, it's hard to, when you're in the auctions, it's hard to check out all the versions of that particular name. So for example, Swiss Life is registered in 200 TLDs, 185 of them are active.
Sure, but you're going to check the .com. Like, let's be realistic.
What I would do is I would check to see if the .com was developed or for sale and what the price is. That's at the most I would do that, but I don't always do that.
But if you don't always check the .com,
no, in fact,
if you're not going to buy a .com,
no, in fact, I serve a different market, so I don't even try for the .coms most of the time. It's not even in my, most of my portfolio is not .coms, so that's not even something I target, because I know that most of them are in the domain find portfolio, that the ones I go for, and they are like short terms that are high frequency search terms on the web. So why would I bother checking? I just sometimes look at what is it, the server names are. Is it domain find or is it Afternic? Beyond that, I don't check further. I don't go to the actual website.
let me say one more thing here. Hold on, Brad. And sorry if my audio, for some reason, mine it keeps adjusting down these last several weeks, so my audio may be high and low. But yeah, if you're looking at Galaxy.app, you don't go, who's on Galaxy.com? You basically, like David said, you know it's probably taken. Swiss Life, he probably thought was taken. It's not as good as Galaxy. But the point is, when you're looking at auctions and you see these great names come through, you know, yeah, I'm sure the .ai is taken. I'm sure the .com's taken. And when you do go to them, like David said, you might want to see, as soon as it might be a big company and you think, oh, I didn't know Galaxy Technologies owns that one. As soon as you leave it, you realize, okay, so it wasn't a for sale lander. That's what you were looking for. A day later, you might forget who was on Galaxy.com. Same like with Swiss Life. He might have went there and said, okay, so it is developed out. And then a few days later, he's thinking, yeah, it was a company. I think it was an insurance company. I guess the point is, you don't always check, and when you do, you're not checking for the reasons to know, oh no, am I infringing on somebody? First of all, he's thinking Swiss
Well,
Life is
but
generic.
we talked about this a lot more a bunch of shows ago, maybe 100 shows ago. But if you're going to hold yourself out to be a professional domain investor, then I'm not saying there's a duty to look for trademarks, but there are many panelists out there that will say, look, this shows up as the first result in Google, and not only the first result, but it's this company that has the .com shows up the first 100 pages of Google search, right? That's probably something you should stay away from, even if you think it's a great brandable name. If you hold yourself out to be a professional domain investor, then that gives you, it's a legitimate business, right? I'm not saying it's not, but that gives you certain requirements, just like being members of other businesses. If you're a professional lawyer, you have to have a bar exam, right? If you're a professional domain investor, then there are some things that you should be held accountable for, and one of those is to know, if there's a big ass company that has like that's using that to the left of the dot uh, as their mark, and should at least at a minimum do a Google search.
So Jeff, if I looked up this name and I was bidding on it, I would check the USPTO sometimes, especially for the .org. And I would have noticed that, oh, they have a disclaimer, express disclaimer for Swiss Life. So that means it's generic. I would have registered it. What's to stop me, whether they're famous or not? Just like booking.com. Like if I had booking.life, what's the difference?
Well, I mean, I think that, you'd have to show, um, you'd have to explain why you registered it, and that you were aware of this other company, but you're marketing it in its generic sense. You didn't contact the Swiss Life group to buy it. Um, you'd probably have better arguments that you would present. But I don't know what this person, I mean, I know what the summary of what they argued was, is according to Luca, but, there is, again, I'm not saying it's a duty to check the Patent and Trademark Office, but if you're holding yourself out to be a professional domainer that buys and sells names, then it's not unreasonable for you to be aware of and to make sure that you're not infringing of the companies that show up in the first results of Google.
Okay, you make the point. If someone go to Bradley in just a second, then Arif. But I wanted to say, um, first of all, yeah, lawyers, they're held to a higher level for many reasons, and that's across a lot of industries. Basically, they are held. So to say a domain investor, what he should do, a domain investor, Jeff, should be ready for a better, basically provide a better answer in a response, but I wouldn't say to avoid registering a name. You're a professional domain investor, like we're going to see in the IP Guardian case. That's a professional domain investor. He bought the domain, exact same reason Swiss Life bought that name. In the IP Guardian case, I'll spoil it, he won the case, and it was, somebody with an exact match trademark, but it's because and he knew of this exact match trademark, but or I think maybe he said he didn't. Well, we'll get to that case. But so Bradley, sorry to cut you off earlier. What did you want to say? And then we'll go to Arif.
Okay, thank you. I think that like if you were to register a domain name and you use false names, regardless, you would end up being perceived as being disingenuous. This person, I don't know, Todd, exactly what he said, but if he said that he didn't know that the .com was taken, then I don't know. I bet you everyone on this call who's a domainer, if they get a .org, they wanted the
Yeah, he
.com
didn't say that.
first,
He said he didn't
right?
know of Swiss Life, who the company was, but he didn't say anything about. Of course, he thought the .com was taken. He
Oh, okay,
yeah, he didn't
okay.
say that.
I'm sorry, because so then it wasn't necessarily a disingenuous statement, whatever he said. Is that correct?
Yeah, he just didn't know of who Swiss Life was, that company, but the panelists said, well, if you went to the .com, you would know who they are. And what we were saying, David and I were saying is, yeah, you can go and know. He might have went to it, but he might have just checked, like I said, those tools that we use as domainers to see, look at all these extensions are taken, 232, the .com, the .ai, and all these. And then maybe there's some tools that will tell you whether or not the names are for sale. You don't have to visit all the websites, but like Jeff was saying, the panelist is saying you're a domain investor, you're probably going to go to that main one, which is the .com, and soon they'll tell us we need to check out the .ai too. They'll tell us we need to do all sorts of stuff.
Right,
Arif,
right.
Arif, what do you
So,
say?
but on one hand, though, before I'll get off, but on one hand, he should have never brought up that point to begin with. Correct?
Oh, that
The
he didn't
point
know him?
that he didn't know that Swiss Life was a business or something. Why did he have to bring that up?
He
About
could have said that in 1998, the day of registration, he didn't know about it, or the registrant didn't know about it. But Todd says that he wasn't the original registrant. He bought it off GoDaddy auctions. I don't know
oh, I see.
when.
Okay, but Todd, you advised him not to represent himself, and that was a good advice.
Yeah, I mean,
Correct?
the bottom line is then he had already had an answer, but he's a smart guy. I think the bottom line is this was still a bad decision because he was trying to be honest and say Swiss life is Swiss life. And even if they didn't like that, it could be like, maybe he should have just said, yes, okay, so once I went to the website, I realized, yes, there's somebody who uses it and they have a trademark, but I had no intention of infringing on, starting an insurance company. And these other sites made me know that I do have, I did have some other options with it, which is where I was headed anyway. Arif, what comment did you have?
Yeah, it's similar to that. I mean, context is everything. Like for me, when I'm going through volume purchasing, right, I'm not stopping for everyone, but you use common sense. Something like Swiss Life, like in non.com, first of all, probably wouldn't have been strong enough for me to actually to buy, right, to justify an investment value. However, if it was something I did see value in, I probably wouldn't have checked the .com, right? If I'm buying like 10, 20 domains a day, to me, there's so many alternate uses for that domain, right? It's not like it's not like an example used before, like Booking Life, right? If bookinglife.com existed, yeah, I could see that there's very limited usage, and you probably wouldn't want to check that if you buy something other than .com. But like Swiss Life, I mean, it's just such an open vessel that to argue, even if you saw the website, I don't think is justification to have it any relevance as to whether it should be taken away or not. There's so many other usages to it that unless the person is using it in a similar way, I feel like it's not really, you're not really infringing on the mark. It's this too open vessel.
Yeah, let me quote what the summary says. And the way I read the summary is different than you did, Todd. So he said, um, in this summary, in the first paragraph, respondent states that he acquired the disputed domain name in good faith through GoDaddy expired domain auction. And I'm going to skip a little bit ahead, and not purposely to target the complainants. That respondent claims he did not know until he received a copy of the complaint. That's where I think he lost the credibility. So I interpreted that by him saying, I never heard of this company until I got the complaint, which I think is not uh, genuine, right?
Well,
He could have said, yeah, I knew the company existed, but it's generic and blah, 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 blah. But if you say I didn't know about this company until I got a complaint, that doesn't sound real, because of course you're going to know when you're pricing your domain, you're going to know how the .com is being used, right? To say you didn't know until you got a copy of the complaint, that's where I think it lost
so
credibility.
I'm gonna just as somebody who has 5,000 domains, like it really depends on how many domains he has, right? If he has only like 20 domains, then yeah, for sure, he probably will know. If you have 5,000 plus domains, when you buy a domain, you might do a little verification here or there. If you see it's open vessel, you probably wouldn't, and you certainly, years later, will not remember what the context of the Google search was. You won't. That's just the truth, right? I've checked Google sometimes for some of my domains, sometimes I don't. It's a very useful tool, but like, do I remember any of the domains I bought 3 years ago? What was the results? No. So maybe he shouldn't have said that he specifically, didn't know, but it's like to say he didn't remember, I think would be totally justified, because, when you have thousands of domains and it's an open vessel domain, again, open vessel domain, it's not like it was, something more specific, but open vessel domain, it's just, it's not something you even think of, because there's multiple uses to it. And there's multiple potential buyers. So to me, there's never really any threat.
David said he didn't hear of
Yeah,
the name.
I understand.
But you're right, Jeff. I mean, that's exactly what the panelists felt like. I just don't believe it. But still, belief and evidence are two different things. And there was no evidence that the person actually did know of them. But that's like, and Arif brings up a great point. Say you bought the name a year ago, you did check the .com, and you go, great, it's not a for sale page. There's some company, it looks like over in Hungary. The guy doesn't even know. He's thinking, fuck, excuse my language. He didn't know Switzerland, Swiss. Okay, it's Swiss Life. Maybe it's a. So he looked at it and said, good, so it's taken, it's not for sale. Oh, and it looks like it is an insurance company. A year later, when the person says, hey, are you aware of their trademark? And he says, no, right. The panelist just said it's unbelievable, but Eric brings up a great point that you're not going to remember. Did I search that website? I mean, I'm a domain investor. Did I search that? And who was on that .com? I don't recall. Was it them or was it another company? So and David said he didn't hear of Swiss Life until today. But anyway, good. We got to get to our
But
other cases.
yeah, but even if you did, again, like it's open vessel. So like there's so many other uses. It could be somebody wanting to talk about cheese, right? Swiss cheese. I don't know. Whatever. There's other usages for this domain. It's
Yeah,
just the fact
skiing.
that
I mean, fuck. Aren't there a bunch of hills over there? I mean, mountains. Skiing is like a big thing in Switzerland. It's like Swiss life. It could be just like the guy just does videos of skiing the Alps. But
Yeah, I think the point I made at the beginning, I think, is important. Look, it's all about context in which the panelist exists, right? Todd, you're in California, right? In-N-Out Burger. Everyone in California knows what an In-N-Out Burger is. Um, but if you had a UK panelist, they may not have heard of In-N-Out Burger, um, right? Or should do it the other way around. If there was a U.S. panelist, they'd be like, everyone's got it. We've heard of In-N-Out Burger, right?
but
It's in your psyche. It's in your kind of bias. And even if
yeah,
you don't say that explicitly, you there is a bias.
yeah, but even then, like the burger context makes it very specific, right? It's much less open vessel, right? Swiss Life could be almost anything. In-N-Out Burger, you're going to be selling burgers, right? It might be, okay, you might sell them wholesale, you might sell them at the grocery store in packaging, or you might sell a burger store, but the context is much more narrow of what you can use it for, right? And in those cases, I could understand like the panelist saying, yeah, you might have wanted to check a little bit more because it's very specific, but Swiss Life is just such an open vessel. It's hard to say why he even should have checked in the first place, right? To me, like that's not a domain I would check because there's just so many potential applications for it that it's even if there are trademarks, most of them won't be relevant, and there's certainly many other usages that will have no relevance to the trademark.
Arif just sure handled that one. Thanks, Arif. But no, Jeff, I agree. Remember George Carlin? He was talking about different names for intercourse, and he goes, "The old In-N-Out." That was one of them. But yeah, so that it could mean different things.
I'm so glad.
The old In-N-Out. That's right. Okay, yeah, we're gonna roll on. We got some great cases. We're gonna get to them. Three more. This next one, ADLEYKINSMAN, AdleyKinsman.com. Okay, it's a name. Adley Kinsman is also the complainant. She's an influencer. Basically, she does a lot of, she creates a lot of scripted and unscripted reality TV for the internet. That sounds interesting to me. I almost want to go and find out what she does. I think it's a, I'm sure it's, I think it's a female. But so Adley is out of Tennessee. She filed this UDRP against Kylie out of Ohio. So basically, the complainant didn't have a registered trademark, but said, everybody knows me as Adley Kinsman. I create this content. I got a lot of followers. And she did a great job of saying, I am known by my name. The content I create is, basically related to people look up my name for my content. But she showed the panelists sufficiently that she does have common law rights since 2021 to her own name, Adley Kinsman. So when she filed this complaint against the person that owns adleykinsman.com, believe it, that person really needed to respond with a good reason to why they registered this domain name. Well, they didn't respond at all, but that doesn't mean they necessarily win. But in this case, so we already talked about the first element. The complainant did show she had common law rights. So that's important for all of us to know that certainly in your own personal name, if you are building a brand or you're out there on the intranet or you're doing stuff and creating content, that you can it doesn't have to be your personal name, but you can establish a trademark without registering it. As we say all the time, that's a common law mark, just as strong as a registered trademark. I say just as strong. It really means the same, but you do have a few more rights when you have it registered. You have a few more protections. But the point is, you do have standing with the common law mark, whether it's a court case or UDRP. The complainant in this case has it said had not registered the mark with the USPTO or any other government trademark agency. I bring that up because David was saying that many times people will register marks with outside the U.S. for, if they're a U.S. citizen, for creative reasons, because it's easier to get a mark, or you can get it done faster without showing your intent to use. But anyway, the complainant, it was important that the panelists mentioned exactly that the complainant doesn't need to show a registered trademark to meet UDRP requirements, like we've just beat up here with the common law stuff. But it's nice to see a panelist acknowledge that, because some people just automatically, well, I got it registered. Listen, if you're using it legitimately, that's the most important thing, and that's what you need really to get your registered mark in the U.S. Anyway, the complainant, or as I mentioned, the respondent didn't reply. The panelist said the complainant, I already said that, proves common law rights. The disputed domain name points to a GoDaddy PPC page. So Jeff, this was one of those where they had done nothing with the name. It was going to a GoDaddy lander, one of those ones. So there was no evidence of any active use by the respondent. And the panelist said the registrant's name on the whois didn't bear any resemblance to Adley Kinsman. So they were questioning right then. This was Charlie, by the way, Charles Kuchenmeister, who, friend of the show, was the sole member panelist on this. Well, I pretty much said so much about the case. I think I've uncovered everything. Jeff, go ahead.
Well, I was just going to say on that point, it shows that education, at least on this point, education helps. And Charlie, who I've been in a number of conversations with, and so have others, where we've hit home on the point that just because someone has pay-per-click ads that the registrar put up does not mean they should be held responsible for or liable for those pay-per-clicks. And although this case didn't turn out in the registrant's favor for reasons we'll get to, one thing that was pointed out in this case is that this conduct, the pay-per-click links, were not put up there by the registrant. They were put up by the registrar, and so this panelist, Charlie, did not hold the registrant accountable for the links that were put on there. Now, so I thought, I took that as saying, great, finally, there are cases where panelists are recognizing this, and so I think that's a great thing. At the end of the day, the registrant lost this case, and I think it's more due to the fact that this is not a common name. This is not something that like a common first name. Adley is not a common first name, and the surname Kinsman is not among the more common family names. So the combination of those two just alone makes one question whether, is this a name that really you could kind of contrive on your own without, knowing the complainant in this case? Like, could you just go, yeah, I'm thinking of all these names to register, and oh yeah, Adley Kinsman. So, as Charlie said, it strains credulity, to imagine that respondent contrived this domain name independently of an awareness of the complainant's name. And so I think that was kind of the factor that tipped the scales. There was also no response, so that doesn't do the respondent any favor. So I think those two things kind of tipped the scales to say, you know what, this person hasn't responded to say why they registered it. And kind of hard to imagine someone just, on their own registering this name so, recently, without having some knowledge of this complainant. And, at the end of the day, they found in favor of the complainant, and Charlie ordered the transfer. So I agree with Charlie on this one, and I like the kind of analysis he did on all these issues. I think it's really one of the better even if you don't agree with the outcome of the decision, it's certainly one of the better written decisions, and that really explains what the panelist was thinking and how it ruled.
Yeah, I wasn't familiar with Adley either. I'm not on Facebook that much. I had to look her up. Grok actually helped me out. I asked Grok if Adley has common law rights in her name, and there is a lot of earned media. She was on the cover of some magazines for having 1 billion views per month on Facebook. So there is that. So Grok said that there's a 70% chance that she can establish common law rights in her name based on her background and her history. So it's not a slam dunk, but she was able to meet that threshold in this case. So that takes evidence. But yeah, I was wondering. Now you mentioned something about registering names, just thinking of names and registering them. Most people do not do that. Most people look at the expired domain lists, they scroll through them. If they see anything that's cool looking, they will click on it and maybe favorite it or save it for like bidding. They usually don't bid to the last minute so that the price doesn't go up. But yeah, that's what they do. They don't think of these names out of the blue. Like I would have thought her last name was Kingsman instead of Kinsman, so I wasn't aware of Kinsman. But yeah, that's how you do it. You look through lists, expired lists. There's 100,000 names expiring every day
I,
on the like actual expired drop lists.
I can't remember. Was this one bought from expired names?
I don't know.
So. I think it was registered. We show the registration date, February 13th, 2024. But I do have some questions for Charlie about this because, Jeff, I felt that he used the GoDaddy PPC page against the respondent because he showed, the respondent didn't reply, and he felt like, okay, so there's no evidence of any active use by the respondent. Didn't say that the PPC links, he was blaming him for specific links, but felt like that shows that you didn't use it. Another thing, the panelist, and you brought it up, said the unique name is evidence of bad faith registration. Usually Charlie wants to see stronger evidence, or in my opinion, of bad faith registration. So, this person could have worked with Adley Kinsman a year
Yeah,
ago making some stuff, and we didn't know, and Adley didn't bring it up. But this person, Kylie, could have, they could have been friends, could have been the web person, or, but I didn't really see the evidence or the proof of bad faith registration. It was just
but here's
confirmed.
here's what Charlie said. Right? Yes. What? Let me go back a second. So what's good is that Charlie recognized that the use for pay-per-clicks was not used by the registrant and therefore considered it passively held. That's what we want, right? That's all that I think that's right. So in other words, he's saying it, yeah, just because it directs to URLs that are um, even if they were related to complainant's business or they weren't, we're not going to count that against the registrant. And that's the right thing. That's what we've been, fighting for.
Sure, but
It
but
says
Jeff,
it
element
says it's
two.
no different, but it's no different than going to a 404, what used to be the 404 page, right? Error. That's what our goal is when we say it shouldn't be considered. So that means if you consider it as, well, the registrant's not using it to direct to a website, that's the registrar doing it. So we're gonna say that it's passively held. And then you go on to apply the Telstra test. And that's what he did.
Okay, so that makes sense. I mean, but I was going to say, so he didn't use that was our goal for the PPC page. So you're not being blamed for it, but I felt like it was undermined by saying it was passively held, and then that holding passively was what made Charlie rule that, so that registrant doesn't have legitimate interest, not making a bona fide use of this name, and they weren't, and basically needs to answer back. If he felt like, I guess Charlie felt like the complainant did make a strong enough case that he wasn't making a bona fide use of it, and that's why the second element the complainant was successful at. And then, of course, they went to the third element of bad faith registration, and he felt like, yeah, this bad faith, there, was in fact, because it's so unique, it was bad faith. But what I learned from this is, if you have a domain that you plan on defending because you bought it for free speech or some kind of criticism site or so on, you better answer, because they're not going to know of it and you could get ruled against. So that's what happened in this case. This was a transfer. I think it was probably a right decision, but there could be something that we're missing because this person didn't answer, where they really didn't register it in bad faith. So they don't have me completely convinced it was registered in bad faith, because I think Kylie may have worked with Adley way back in the day, just a year ago, and when they registered the name, everybody was all buddies. I'm just giving a far-fetched possibility. All right, this next case is interesting. IPGuardian.com. The domain was registered in. It was basically picked up on NameJet for $450. The complainant was IP Guardian out of Australia. They were self-represented versus Mira Holdings. This person at Mira Holdings has dozens of UDRPs filed against them in their names. In this case, they were representing themselves. In many cases, they'll use a lot of the lawyers that we know, but in this case, they're representing themselves, and they basically were had a smarter answer than our friend did in the Swiss Life case, because very similar. This person bought the name IPGuardian.com. He's a domain investor. I'm pretty certain, this domain investor, I think it wasn't here, he priced the name at 42,556 Australian dollars, which is basically 25K US. But he bought this name IP Guardian for the same reason that the person bought Swiss Life. Just felt like it was, these two words go together. In IP and Guardian, they make sense. It's sort of two generic words, but together, it's like IP protection, IP Guardian. But IP Guardian, I'm sure it was more attractive when he looked at it and saw, IP Guardian LLC or whatever, that is a company pretty big out of Sydney. It's a law firm out of Sydney, and they've had a trademark for IP Guardian since 2014. And like I said, Mira Holdings, that is a pro domain investor, in my opinion. One, we've seen just so many of his cases. But anyway, let's see, the TM, what do I have here? My notes, I love looking at them. TM predates registration by 6 years. Yeah, so the trademark, in this case, IP Guardian, preceded the registration because, like I said, the domain owner bought it right off of NameJet. So this was a great example of, he answered fantastically because he won the case. The complaint was denied. He bought the domain for the same reason, really, as the guy in case one, the Swiss Life case, and both complainants in each case had a trademark that was established before the domain name, but yet there was a 3-member panel in this case. Jane Seeger, Andrew Lothian, and Matthew Kennedy ruled that there was no bad faith registration. When this guy acquired it in 2021 on NameJet, he acquired it because it was two terms that go good together, and no one said, well, I mean, I'll throw it to you guys. Did anybody say, Jeff must have taken off. He probably had to work. David, did you find out if, did this guy say that he knew of this complainant, or did he even mention that in the case?
I don't remember. I don't remember reading that.
Yeah.
They may have, but they don't have a U.S. trademark, and it's a generic term, so they don't care. That's the general point. Now, how many? I did a Google Trend search, and there's only primarily searches for it in Australia, but there are there's an IP Guardian in New Zealand, and there's one in actually Delaware. So there is a U.S. company with the name IP Guardian and Hong Kong. So there's many potential buyers. So in this case, even if there was this Australian trademark and well-known Australian website. It's not well-known around the world, and they have limited rights. So yeah, this is an investable name in most investors' books.
Yeah.
What do you think, Jeff?
Just
Would
like
you invest in this
SwissLife.org.
name?
Go ahead, Jim.
Yeah, I mean, this is another one, right? Like if you did the search for this and you type in IP Guardian in Google, you're going to get a whole bunch of different companies, right? So that like again, these are two different cases, the Swiss Life and this one, but when you kind of there's no famous, I'm sorry, no offense to the IP Guardian in Australia, but this is not a famous mark. And there's no argument made that it is. And so this is not, so I don't consider this very similar to the Swiss Life one, but I can understand why you kind of group it together because it's two, terms that are descriptive or generic and you put them together. In this case, they're still descriptive and generic. But yeah, I think there was enough information here showing that, look, um, these you are a domain investor. This is it's clear that there's not that these two terms used together is very commonly put together, guarding someone's IP, and so the panel came to the conclusion that the right conclusion that this is that there was no bad faith here. And there was no targeting, right? There was nothing else shown that this respondent was targeting or going after the IP Guardian um, in Australia.
Yeah, I was looking to see if he had it for sale still. Yeah, it's on Afternic with a maybe it's GoDaddy land or price inquiry. But okay, so we'll get to our next case. Everybody, thanks for being here. We went an hour and a half. We normally are done by now. We got one last case we'll get through real fast. But the IPGuardian.com case, the domain owner got to keep it. He's a domain investor. It's a type of name. He saw it on NameJet. He probably knew exactly this, like a lot of us. Great, 2 words. Let me check it. Oh, great, ton of usage out there. Couple companies around the world are using it, have trademarks on it. Probably something I'm going to be able to. It's a good one to own. Have potential buyers and even some potential new buyers. Somebody wants to use it. So good investment. We'll see. Still got it for sale. This last name, interesting. SwiftSight.com, SwiftSight.com. It was owned by Huge Domains. So I bring it up. Igor, a friend of the show, sent me this case because he said, hey, this is one that's, by the Asian Domain Name Dispute Organization. We don't see many cases that come in. Usually it's WIPO or the forum, but this was the Asian version, Asian service provider down there. So the complainant in this case, AIRS Medical Inc. out of Korea, filed this UDRP against Huge Domains. The long story short is Huge Domains bought the name in 2003. A day later, they listed it on Huge Domains, like they do. They listed it for $4,395. It's probably still there. I haven't checked it. But the complainant said the disputed domain name was registered to sell to a trademark owner or to a trademark owner's competitive for costs that were above their, what they paid for it. Well, that actually is true. It just didn't win him this case. So as we close up here, when a complainant says that, you guys, that the domain was registered to sell to a trademark owner or a competitor, could be, or to even someone else, maybe a new user. But it wasn't a convincing argument there. And this complainant, big healthcare company that does AI-based imaging and stuff, didn't come into existence until a couple years ago. So this predated domain name really is what won the respondent, basically made this respondent successful. But did you notice anything in this case that was interesting you want to share?
The name is cheap, and the filing fee for the UDRP complaint is a lot. So why did they waste their money? They should have just bought it because they just got their trademark and this name was registered in 2011. So why do they think they can grab it through a UDRP and get a discount, technical discount, basically? That's theft in my book.
Well, certainly, well, and they found reverse domain name hijacking, but um, they, it just shows that there's a lot of law firms, whether here in the U.S. or in Europe or in Asia, that are not specialists in this kind of thing, and they will file a case based on anything without knowing or caring about certain fundamental um, issues, such as when was the domain registered and when did you get trademark rights. Uh, there's a lot of lawyers out there, a lot of people out there you can hire. You just need to make sure you hire someone that is knows what the hell they're doing. Um, so yeah, I mean, they didn't really rule on anything other than it's not that it's not that they did much evaluation in this case. It's really just look, it's the 10 year or it's 10 years or whatever before uh, that was the whole case, right? They didn't really go into the other elements. Sure, they have a trademark, so that satisfies the first element. Rights and legitimate interest, they don't even look at. And then all they look at for bad faith is, the years. So I like it. It's a short opinion. It's to the point, and it was the right outcome.
Yep, it was registered so far in advance of the trademark that the panelists just said, and the panelists Ho, Hai, and Nam said, yeah, that's complaint denied. And then this complainant should have known that they couldn't have won, so did add on the RD&H. I didn't get to see who was representing Huge Domains. It doesn't say. I'm surprised if they don't use one of the attorneys that we know. They might have in-house counsel, but
I think this one's easy enough for them to do on their own.
you know,
This one was kind of, you didn't really have to make any other arguments other than we acquired this 10 years before they had the trademark rights.
yeah.
Period.
And David was absolutely right. $43.95. You spent a lot of money developing AI imaging. You got you launched your company. You can't afford $43.95. Very bad decision by this complainant. All right, that's it for today. Listen, on Thursday, 10 a.m. Pacific, 1 p.m. Eastern, Josh and I are doing the DNX show here on X. Check it out. Got a lot of topics about domain investing. If you're, a domain investor, we talk every week about how can you make money in this space in domain investing. Come join us. We appreciate it. That's Thursday, 10 a.m. Pacific, 1 p.m. Eastern. Until next week on next Tuesday, we'll see you here at Domain Name Law. Take care. Have a good rest of the day wherever you're at.